It's 2 o'clock. We'll go ahead and get the ball rolling here. If we'd all please rise up, and Tom will lead us in prayer.
Father in heaven, we seek blessings on the tasks before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We gather to make decisions for our community. May we use only our best skills and judgments, keeping ourselves impartial and neutral as we consider the merits and pitfalls of each matter that is placed before us, and always act in accordance with what is best for the city of Tarpon Springs. This we pray. Amen.
Amen. And please face the flag and recite the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. If you would please silence your cell phones or turn them off. And Bobby, if we could have a roll call, please.
Mr. Sansoda?
Here.
Mr. Casey?
Here.
Mr. Kramer?
Here.
Mr. Bessie?
Here.
Ms. Archer?
Here.
Mr. DeMontis?
Here.
Mr. Pawlitzki?
Here.
Mr. Plunkett?
Here.
Mrs. Dabb? Here. I can please your roll call.
Thank you. All right, we'll just move right on to item number 1.
We need to swear in everybody.
I have to be sworn in.
Oh, I'm sorry, yeah. Thanks. You have somebody coming in, you said? Oh, do I need to raise things in?
Mm-hmm.
Okay.
We need to back up just a little bit since there's someone else here to read the hearing procedures.
Yeah. Okay. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure of this board with each case on its agenda is as follows. First, the city presents its witnesses and exhibits, after which the violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the violator is allowed to make a presentation and present any evidence or documents. Then the city can question the violator's witnesses. After both rounds of testimony, both on the part of the city and on the part of the violator, each party is asked to give a closing statement, first by the city, then by the violator. After those 3 steps are taken, this board then closes the public hearing portion of the case to discuss it and take appropriate action. Before we begin the public hearings, we will have all potential witnesses stand up and be sworn in by the secretary of the board. Yeah.
Can you raise your right hand?
Do you swear to testimony about to give the whole truth and nothing but the truth?
I do.
Thank you. And again, please turn all cell phones off or put them on silent. And item number 1, please, on the agenda.
Good afternoon. My name is Cindy Sander. I'm the Code Enforcement Inspector for the City of Tarpon Springs. This is case 13-200000034. The property address is 563 East Spruce Street, and the property owner of record is Jacqueline E. Morgan. I believe she's in the audience today.
Okay.
And we're going to have some photos, have her approve some photos first.
And Ms. Morgan, if I could have you sit over there and state your name and address into the microphone, please.
My legal name is Jacqueline Haynes.
Okay.
I was married since I purchased this property.
Okay. So, Morgan was your maiden name?
Correct.
Okay. And your address again?
The property address is 563 East Spruce Street. It is a rental property.
Okay.
Not my address.
You need to state where your address,
My address is 2223 Lynn Court, Dunedin, Florida, 34698.
Thank you.
Yeah, my tenant has it installed. Thank you, sir.
Okay, so how do you want us to, what's your last name now?
My legal last name is Haynes, Haynes.
Haynes, so that's, we should call you Ms. Haynes.
Yes.
Okay, thank you.
This was a proactive case on August 23rd of this year. I noticed that a new fence had been installed on this property without a permit. The property was in violation of Code 6-1, Building Code Adopted, Section 105.1, Permit Required. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was sent a notice of violation on August 26th of 2013 and a notice of hearing sent first-class mail and certified return receipt on September 13th of 2013. A copy was also sent to the tenants at this address. A site visit was conducted prior to each notification being sent. The property was posted on September 26th. I conducted a site visit yesterday and found that the fence was still up. I called Laney and Development Services, and she stated that the property owner did come in on the 8th to submit her fence permit application, but Laney could not accept it because there was not a survey attached. This property is in violation of Code 6-1 and Section 105.1. I recommend a compliance date of October 31st of 2013 and a daily fine thereafter of $50 a day. This property owner has never contacted the Code Enforcement Office.
Does the board have any questions for the city?
I have a question. The person before us today, what's her connection to
She's
this
the property owner.
Property owner. Thank you.
I have one. Cindy, if she gets a permit, the fence looks like it's okay as far as setbacks.
Well, then she'll have to, I don't deal with that. Once she's issued the permit, I close my case. Then she's under the auspices of Development Services to comply with the terms of the building permit for the fence.
Thank you.
I have a question. Cindy, is it feasible that from the 11th or the 10th today to the 31st, that is enough time frame for her to submit and get a viable permit, or?
Well, they were notified on August 26th that they had to apply for a permit. So at that point, they should have been in contact with Development Services to find out what the requirements would be. And so far, the time allotted has been more than adequate to apply for and obtain a survey. So
the first notice that I ever received was
Actually, we'll open up. I'm going to have you speak in just a minute. Thank you, Ms. Haynes. I'm sorry, Cindy. Are you finished?
No, I'm done.
Okay. Any other questions by the board for Cindy, for the city? And then Ms. Haynes, would you like to make an opening statement?
I was just going to say that the first notice that I received about the fence being in violation was the certified letter that I received after the 13th. I was told by my tenants that they had applied for the permit because they're the ones who had it installed. So that it was a shock to me to find out that it hadn't gone through. And what they said was that they were told if they applied for the permit after they had installed the fence that it would be less expensive. So, and that they wouldn't need the survey. So I said, well, I have a survey for the property, so I don't really understand why they just come to me and ask me for it. So she said she wasn't aware that a survey was required. So I've been looking through all of my documents trying to find the survey for this property, and I have not found it yet. That's why I came up to the office on the 8th and asked, what do I do if I can't find the survey?
The 8th of October?
Yeah.
Okay.
The first I had been noticed was the September the 13th. They didn't even tell me that the code enforcement had gone to the property and posted or anything. I wasn't aware of any of that.
Okay. So the first notice that you received was a
after
certified letter that you received or given to you by the tenants?
No, this was certified mail to my property address, mine, that I'm physically
on September 13th.
Yeah, it was after the letter's dated the 13th, so I probably received it the 14th or
Okay.
so.
Okay.
That was the first notice I had ever received that it was in violation.
Okay.
But I am diligently trying to find the survey for the property, but I bought it in '99, so I'm looking through almost 14 years of paperwork trying to find a survey. Yeah, I haven't found it yet, but I know I do have it. And I didn't think it was a huge ordeal because we literally pulled out a chain link fence and put in the privacy fence. So it was already fenced. We just replaced one with another. So I didn't think a survey would be needed since it was already plotted.
Okay.
I can get a survey.
You might mention that in the development service, that it was a replacement.
Justin?
I did.
I'm sorry, what was the question?
I was mentioning to Ms. Haynes that being clear with development services might help that situation.
Yes, she said because in the past 10 years that there hasn't been a permit that needed a survey, that they don't have one on record because the fence was up when I bought the property.
Does anybody else on the board have any questions for Ms. Haynes? Do we even know if a survey from 1999 is going to be valid?
I would question that.
You may want to talk to the office here.
Laney again?
And, Laney, and find out if that's even going to be
She
valid.
knew when I spoke with her on the 8th that it was from 99, and she said to go to my title company that I originally bought the house with and see if they had it on record, so she didn't make it sound like it was going to be a problem.
Okay.
It's not a question, but the county records, it's on microfiche, but it's also recorded with the county.
I asked her that, and because I know in my property in New York that I can go to their office, to their building, and actually pull it up and have a photocopy made, and she said she didn't know where that would be.
That's at the county building, which is downtown Clearwater.
Okay, I can go down
At
there.
the clerk's office.
Mr. Chairman, could you ask the witness to speak into the microphone? I can hardly hear her.
Okay.
Sorry.
Yeah. Yeah, it's real tough to pick up the, do you have any, Carl, do you have any questions for what you may have missed? Or?
No, I'd just like to hear all of the testimony so I can make an impartial decision.
Okay. All right, well, in that case, City, do you have a closing statement that you would like to make before we?
No, I do not.
Okay. Then, Ms. Haynes, do you have a closing statement that you would like to make? Now, once you make your closing statement, at that point, I will close the public portion of this, and there won't be any more statements to be made, and we'll discuss among us as a board. So do you have any closing statement that you would like to make before we make our decision?
Just that I have no problem getting the permit and paying the permit fee. I just would obviously need a little bit more time to try to get my survey. So if we could do it through the end of October, I don't think that would be an unreasonable amount of time for me to obtain the survey.
Okay, so you're pretty comfortable with having a compliance date by October 31st. That's fairly comfortable for you.
With me being able, I don't know how long it takes once I apply for the permit, but with me being able to apply for the permit by the 31st, yeah, I don't see a problem with that.
Okay. All right. Then at this point, I'm going to close the public portion. And does somebody want to make a motion on this and we can discuss?
I'd like to make a motion.
Okay.
I move, based on the testimony, evidence, facts presented in the law, that at the time of the alleged violations, sections 6-1 building code adopted and sections 105.1 permit required of the code of ordinances of the city of Tarpon Springs were enforced. The respondent has until the 15th day of November 2013 to come in compliance with the code sections, or a fine of $50 a day per day shall be imposed each day thereafter until the respondent remains in violation of the said code sections.
Second.
All right, a motion and a second. Any discussion? I like the extra 2 weeks, to be honest, just to, because even though she can get her work done in an expeditious manner, we never know. Okay, then how about a roll call vote, please, Bobby?
Mr. Kapinski?
Yes.
Mr. DeMasis?
Yes.
Mrs. Archer?
Yes.
Mr. Bessie?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
Yes.
Mr. Sansetta?
Yes.
Motion carries.
All right. All right. So I would get things wrapped up as quick as you can so that the paperwork can get back to us. That's the reason for the 11:15 was so that when you file, you can get it back in a timely manner, so.
Yep, I will take care of it.
Okay,
Thank you.
thank you. Item number 4 on the agenda, please.
This is case 13-8000581. Property address is 482 Kiwi Street. It is a vacant lot, and the property owner of record is Fred N. Collins. On July 25th, we received a complaint that this vacant lot was overgrown. I conducted a site visit that same day and determined that the lot was not overgrown and scheduled a reinspection in another 2 weeks. I went back on August 6th and found that the lot was now overgrown. The property was in violation of Code 8-40, duty of maintenance of private property, and 8-52, nuisance prohibitions. There's no one in the audience for this case, so I'm going to start the photo.
Okay.
This is the after photo taken yesterday. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was sent a courtesy letter on August 6th of 2013, a notice of violation on August 26th, and a notice to hearing sent first-class mail and certified return receipt on September 11th. The documents were also sent to the previous owner and to another person affiliated with this property. A site visit was conducted prior to each notification being sent. On August 23rd, I spoke to Alan Dirks, the previous owner, who has been acting as the contact person for this property. We discussed this case, and I told him that due to the number of cases against this property, even if the property came into compliance, we would be taking him before the Code Enforcement Board to be established. I also told him that the property owner needed to contract with someone to have the property maintained at least every 2 weeks during the growing season. He stated that he would have the lot mowed by Labor Day. This property was posted on September 26th, and yesterday I conducted a site visit. The lot had been mowed. There have been 14 cases against this property since 2007, and it never gets mowed unless we send a letter. So this property is in violation of codes 8-40 and 8-52 to be established.
Board, does anybody have any questions for the city?
Yes, did you say there's 14 violations since 2007?
Yes.
Okay.
Cindy, if and when they come before us again, I recall you let us know that there's been 14.
Yes, it would come back to you as a repeat violator, and
So this is just to establish
correct.
a violation?
Yes. There's no fines currently for this property.
Would somebody like to make a motion?
I will.
Okay.
I move based on the testimony, evidence, facts presented in law, that the respondent was in violation of Section 8-40 and 8-52 of the Tarpon Springs City Code of Ordinances. Okay.
You can just finish it with at the time of the inspection.
At the time of
now
the...
in compliance.
I'm sorry, I interrupted you.
Oh, no, I'm sorry, I jumped in there. I'm just saying you can finish it off by saying in violation at the time of the inspection and is now in compliance.
Okay, was in violation at the time of the inspection, but is now in compliance.
Second.
Okay. Any discussion? Bobby, if we could have a roll call, please.
Mr. Swansky?
Yes.
Mr. DeMassa?
Yes.
Mrs. Archer?
Yes.
Mr. Plessy?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
Yes.
Mr. Sanford?
Yes.
Motion carries.
Sir, what case are you here for?
Number 9.
Number 9, 23S Walton Avenue? Okay. If you want to come forward and please state your name and the mic and your address, we'll go ahead and proceed straight away to your case, so you don't have to wait. You know what, I'm sorry, we need to swear you in first. If you don't mind, stand up and raise your left hand. Your right hand. And please state your name and address in the microphone for us.
Okay, my name is Milad Mikhail, and my tenant address is 23 South Walton Avenue, Tarpon Springs, Florida 34689.
Okay. Now, Mike Claire.
No, Mike is my landlord. I'm the tenant.
You're the tenant. Okay. Got it. Okay. Thank you. Okay, Cindy, case number 9.
We have some photos that the gentleman's going to have to verify for us first.
Okay.
Okay. All the signs, she told us we need to remove it. Everything.
Yeah, just let us know, are those documents in order? Are those pictures in order? Do you agree with them?
Yes.
Okay. We'll have you do a verbal testimony in just a few moments after the city does theirs. Thank you.
Thank you.
This is case 13-8000741. The property address is 23 South Walton Avenue. The property owner is Mike P. Claneris. The business is Easy Stop and Shop, and Flopatier Incorporated and Milad H. Mikhail are the business owners. This is being brought before you to be established. This is a proactive case on August 21st. This business had attached multiple signs to the front support posts along the plaza. The property was in violation of Code 181.00, signs specifically prohibited. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, and the business and business owners were sent a notice of violation on August 22nd and a notice of hearing sent first-class mail and certified return receipt on September 3rd. A site visit was conducted prior to each notification being sent. The property was posted on September 26th, and I conducted a site visit yesterday, October 9th. All of the illegal signs had been removed. They were in compliance. This property was in violation of Code 181.00 to be established.
Does the board have any questions for the city?
Where is Walton Avenue? Where is this located?
Do you know where Dobie's funeral home is on Tarpon Avenue?
Yes.
Across the street.
It's the side shopping center.
Yes. There's a jewelry store in the front of the plaza, and then the plaza is elongated down Walton Avenue.
Any other questions for the city?
The photos you're looking at are the before photos. All the illegal signs are gone.
Mr. Mikhail, did I pronounce that correctly?
Yep.
Okay. If you would at this time like to make an opening statement, please.
Yeah, I'd like to obtain all the regular rules and all the whatever you guys want, but I don't see no fair that Cross Street had the same problem and they never remove it and never get any noise. I saw a lot of business in the same street, and all Tarpon Springs had the same signs, had everything all over every day, and I never see nobody tell them to move it out. Cross Street had a restaurant, had the sign without no permit, I come to the city and ask about what's the law for the signs, and she checked it, and she told me Cross Street, she never have a even permit, and nobody bugged them. Whatever I put any sign in my store, even little thing to direct the customer to come to the store, because my store is all the way inside. It's not all the way in Tarpon Avenue, so people can see because the business is down and economic is very down. I'm trying to do anything to get customer to my business, so not to make me close down. And I have the letter from the enforcement the second day right away. So if I have the same problem, why the cross street keep the same stuff in the same day?
Unfortunately, we can't address any business but yours. I'm relatively familiar with the area, but I can't say what signs are up and what signs are down, what signs are illegal. We're right here just to address the fact that your business was in violation. Now, I appreciate again that you've got it back into compliance in a timely manner, but whether or not another business is out of compliance, those will eventually be brought here to this board, if indeed they are within the city of Tarpon Springs. But again, we're here.
Okay, what's the minimum?
To getting rules and regulations to you. I mean, do we have?
I understand that and I respect that.
Pardon?
Okay, I respect the rules.
You just
okay.
come up.
Yeah, it's everything already clean and everybody is out. But how I'm gonna direct customer to my business if they're all the way inside the street and I have nothing can show their business?
I wish. I understand the disadvantage that you have, but we cannot do anything to excuse a violation for one business that we don't for another. When they come before this board, they are all treated equally, and nobody's picking and choosing. And so eventually, if the nearby business is out of compliance, they are going to be coming before us for the exact same thing that you are here for. But unfortunately,
so if I want to complain, excuse me, if I want to complain about my other business, my competition, he do the same thing, but nobody bug them. So what I have to do?
No, actually, if you see somebody that's what you consider to be out of compliance, you can bring it to the attention of the city, and the city will probably send an inspector out to take a look.
Okay.
And the same action will take place if they are in violation.
Yeah, because this is advantage for them.
But today we are here for you.
Okay. Just I want to understand what I can do, because they get advantage now. They showing the customer what they have, but I can't.
Well, if somebody's out of compliance, I mean, just like if I have a neighbor that's got a bunch of garbage in his yard and it's not getting moved, I could call the city and they'd come out, and if it's in violation, the city will inform that person that they need to
Thank you.
take action. Do you have any other?
No, thank you, sir.
Does anybody have a question for Mr. McHale? Cindy, you were going to say something. Do you?
Yes.
Turn the microphone towards you.
Okay. I even conducted a site visit in which I had a conversation with the gentleman and provided him with suggestions on what signage he was allowed and recommended that he check with planning and zoning. He does have a sign on the freestanding plaza sign that's on Tarpon Avenue. He made a complaint about his competition across the street. I conducted a site visit. There were no illegal signs on the property. The gentleman, I had a previous case with that particular convenience store, and he had removed the signs. Mr. McHale complained about some other locations. I conducted site visits. I found the Shell gas station to have 2 illegal banners. A case was opened, and the 2 banners were subsequently removed. I take offense to a statement that was made that there's favoritism. There is no favoritism.
Okay. And will you consider that your closing statement, or do you have any?
Yes.
Okay. And Mr. McHale, do you have any questions?
No, thank you, sir.
Okay. Would you like to make a closing statement at this time?
I'm just gonna obey to what regulation is.
Okay. All right. Then at this point, we're going to discuss this among our board. So at this point, we're going to close the public portion of this testimony.
Okay.
And we'll discuss among ourselves. Is there a motion that anybody would like to
thank
make
you.
at this time on this?
I'll make a motion.
Okay.
I move based on the testimony, evidence, facts presented in law that at the time of the inspection, August 21, 2013, the property was in violation of Code 181. Presently, the property is in compliance and has been cited at this time to establish the past record.
Second.
All right. Any board discussion? Okay. Bobby, a roll call, please.
Mr. Kalinsky?
Yes.
Mr. Demasis?
Yes.
Mrs. Archer? Yes. Mr. Bessie?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
Yes.
Mr. Sansoda?
Yes. Okay. Thanks for letting us skip ahead. Item number 5, please.
This is case 13-800000582. The property address is 474 Kiwi Street. It is a vacant lot, and it's owned by Mark A. Palazzo. We received a complaint on July 25th that this vacant lot was overgrown. This vacant lot is adjacent to the other vacant lot that was previously presented to you. I made a site visit the same day, noticed the lot was not overgrown, and scheduled a reinspection for 2 weeks. I conducted a site visit on August 6th and found that the lot was now overgrown. The property was in violation of Codes 8-40, duty of maintenance of private property, and 8-52, nuisance prohibitions. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was sent a courtesy letter on August 6th, a notice of violation on August 26th, and a notice of hearing sent first-class mail and certified return receipt on September 11th. The documents were also sent to the previous owner. A site visit was conducted prior to each notification being sent. On August 23rd, I spoke to Alan Dirks, the previous owner, who's been acting as the contact person for this property. We discussed the case, and I told him that due to the number of cases against this property, even if the property came into compliance, we would be taking him before the Code Enforcement Board to be established. I also told him that the property owner needed to contract with someone to have the property maintained at least every 2 weeks during the growing season. He again stated that he would have the lot mowed by Labor Day. The property was posted on September 26th. A site visit was conducted yesterday, October 9th. Most of the lot had been mowed, but there were still some tall weeds along Kiwi Street and along the northern fence line. There have been 14 cases against this vacant lot since 2007. This property is in violation of Codes 8-40 and 8-52. I did notice on my way to this hearing today that the weeds in the back had been mowed, but it was after the cutoff date, which was yesterday, or actually Tuesday. I recommend a compliance date of October 24th and the daily fine thereafter of $25 a day.
So the tall weeds, I mean, is it technically in compliance then?
No. Well, it is, but not per the notice of hearing.
Okay.
They were supposed to be in compliance Tuesday by 5 p.m.
So we would consider this in violation still of Code 8-40?
Right, and what I can well do is go out tomorrow and conduct an inspection, find them in compliance, so non-compliance would be for the 2 or 3 days.
Any questions for the city? Motion?
I'll make it.
Okay, thank you, Becky.
I move based on the testimony, evidence, facts presented in law that at the time of the alleged violations, sections 8-40 and 8-52 of the Code Ordinance of the City of Tarpon Springs were enforced. The respondent has until the 24th day of October to come into compliance with the code sections, or a fine of $25 per day shall be imposed for each day thereafter that respondent remains in violation of the said code sections.
Second.
Any board discussion? Roll call, please, Bobby.
Mr. Kalinsky?
Yes.
Mr. Demasis?
Yes.
Mrs. Archer?
Yes.
Mr. Bessie?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
Yes.
Mr. Sansoda?
Yes. All right, thank you. Item number 6, please.
This is case 13-800000676. The property address is 714 Locust Street, and the property owner of record is Walter Thomas Hudson. There is nobody in the audience for this case, so I'll start the photos. We received a complaint on August 6th that this property was not being maintained. The next day, August 7th, I conducted an inspection. The rear and side yards were overgrown. The bushes and trees were overgrown and encroaching onto and hanging low over the sidewalk and street. I did notice that a lease pending for foreclosure was filed on January 31st, 2013 by Deutsche Bank. This property was in violation of codes 8-40, duty of maintenance of private property, 8-52, nuisance prohibitions, 7-12, National Fire Codes adopted, 18.2.2.5.1.1 Fire Code tree maintenance, and 133.02 tree maintenance. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was sent a courtesy letter on August 8th, a notice of violation on August 26th, and a notice of hearing sent first-class mail and certified return receipt on September 16th. The documents were also emailed to Deutsche Bank and to Chase. A site visit was conducted prior to each notification being sent. The documents sent to the property owner at 2 different addresses were returned. On September 13th, we received a letter from Chase stating that they were no longer servicing the property. They did, however, give us the name of Select Portfolio Servicing Incorporated, along with their mailing address. A copy of the notice of hearing was sent to them. The property was posted on September 26th. I conducted a site visit yesterday, October 9th, found that the front yard had been mowed, but not the side and rear yards. The bushes had been trimmed, but not to code. The trees were still hanging low over the street and sidewalk. This property is in violation of codes 8-40, 8-52, 7-12, 18.2.2.5.1.1, and 133.02. I recommend a compliance date of October 28th of 2013 and a daily fine thereafter of $25 a day.
Did you get anything back from Select Portfolio?
Not yet.
Have you gotten anything back from any of the companies that you sent notices?
Well, Chase had sent us a letter saying that Select Portfolio was in charge of servicing the property, so...
Just from Chase then and nobody else?
Yeah, I think Deutsche Bank got the return receipt.
Okay, so they...
Did Select Portfolio, did you send them notice return receipt?
We got a return receipt from Select Portfolio.
What was the date of that, Cindy?
Of what?
Of that return receipt.
Where?
My question, I guess.
It's not dated.
All right, but you
there
probably...
There is no spot for a date.
I'm assuming that shortly after you heard from Chase that you sent that to them, to Select Portfolio, like early September, mid-September.
We got the return receipt from Select Portfolio on September 26th.
Okay.
And it usually takes them a little time to get the ball rolling.
Okay, so...
Thank you.
Any other questions for the city? How about a motion?
I'll make a motion.
Thanks, Jerry.
I move based on the testimony, evidence, facts presented in law, that at the time of the alleged violation, sections 8-40, 8-52, 7-12, 18.2.2.5.1.1, and 133.02 of the Code of Ordinances of the City of Tarpon Springs were enforced. The respondent has until October 28, 2013 to come into compliance with the code, or a fine of $25 per day shall be imposed for each day thereafter that respondents remain in violation of said code section.
Second.
Okay. Any, board discussion?
I almost would like to see that time higher, just because there's just no communication, and if Select Portfolio was the one who did go out and do some work on the place, if they'd called Cindy, they would have found out that it wasn't good enough.
How do I put this? The property maintenance companies can only do what the bank tells them they can do. And typically it's only mowing. Once they get the notice from us, they usually will put in a work order that has to be approved by the bank for the additional cost, and then they have to get approval for all that, and then the property preservation company will go out and make the corrections. But it does take time, considering that right now it's taking close to 5 years for foreclosures to change hands. So it's just a lengthy process, and I don't think, you should really treat them any differently than you treat somebody who's residing in their property. It's just the way it is right now. It's the economy, and it appears that we're going through a second phase of foreclosures. There was a lull for a while, and it seems to be starting back up again. But we've got, a pretty good handle on the property preservation companies and who to contact at the bank, so it's just taking a little bit of time for them to do what really needs to be done.
Okay.
Well, we can, take a roll call, and if it fails, then we can make a new motion. Any other board discussion? Then, roll call, please, Bobby.
Mr. Slinsky?
Yes.
Mr. DeMontis?
Yes.
Mrs. Archer?
Yes.
Mr. Bessie?
Yes.
Mr. Kramer?
Yes.
Mrs. Casey?
No.
Mr. Sansota?
Yes.
Here, 61.
Okay. Item number 7, please.
This is case 13-800000679. The property address is 705 North Florida Avenue, and the property owner of record is Timothy Thompson. We received a complaint on August 8th that this property was vacant and the pool water was green, and that there was furniture on the front lawn. I conducted a site visit on August 9th and found the house was vacant. There was a couch and some other furniture on the front lawn. The fence gate on the south side was missing, and the gate on the north side did not lock. The side door on the south side of the house had been removed. The pool water was green and unsanitary, with frogs living in it. A neighbor told me that the property owner had died, and this partner vacated the house. This property was in violation of codes 8-40, duty of maintenance of private property, IPMC 9-1, International Property Maintenance Code adopted, IPMC 302.7, accessory structures, IPMC 303.1, swimming pools and spas, IPMC 303.2, swimming pool enclosures, and IPMC 304.2, protective treatment. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was sent a notice of violation on August 9th and a notice of hearing sent first-class mail and certified return receipt on September 10th. The documents were also mailed and emailed to SunTrust Mortgage. A site visit was conducted prior to each notification being sent. The documents sent to the property owner were all returned. This is kind of a sad case because these two gentlemen really had the nicest house on the block. And it was immaculately maintained. They were very proud of their property, and it showed in the condition of it. And it's just really sad to see what's happened. The property was posted on September 26th. During that site visit, I noticed that the side door opening had been boarded up, and there was a sticker affixed to the front door stating that the property was being serviced by Safeguard Properties. When I got back to the office, I contacted the person at Safeguard and told him about the issues, and he stated that he would prepare a work order to have them corrected. I received an email on October 8th from him stating that he placed a rush order on the work to be done. A site visit was conducted on October 9th, and there was no change. And this is in violation of codes 8-40, IPMC 9-1, IPMC 302.7, IPMC 303.1, IPMC 303.2, and IPMC 304.2. I'm recommending a compliance date of October 28th of 2013 and a daily fine thereafter of $50 a day. As you can see, some people entered the property and started stripping things from it, whether it was the gentleman's partner or vandals. But they pulled out little ponds, fish ponds that were throughout the property. They stole the pool pump. Somebody was caught who was going to remove the hot water tank. And it's just really, it's been trashed on the outside. They pulled out fixtures from the inside until the door got boarded up. And the door was taken. It was a beautiful leaded glass door.
Who owns the property?
It's the heirs of Timothy Thompson.
The heirs?
There's no lease pendants filed on it, and it's just we contacted the mortgage company to get them to go out and secure it because of the death.
Have you received acknowledgement from the mortgage company? Are they aware, or you sent?
Well, that's why they notified Safeguard Properties, who's a property preservation company.
Oh, okay.
And I have a good contact person there, and so I immediately got hold of them and told them what the issues were, and I'm confident that within the next couple of weeks they'll be able to correct them all.
So is it a safety hazard?
Yes, because there's free access to the pool.
Any other board questions?
Yes, I have a question. I don't know, you said you looked in, were able to look in. My concern is, are they using it for a dump, or did somebody steal that couch and then thought they might get caught and then left it in the front yard?
I don't know if it was the partner who did it when he was leaving, decided he didn't want it, but there is nothing left in the house.
There is no furniture inside or
No.
anything like that?
No.
You say that people can get into that pool?
Mm-hmm.
I don't think we should wait till the 28th of October, then.
Well, you have to give them reasonable, I just contacted, and heard from Christian yesterday. You've got to give them a reasonable amount of time to get the bank to approve the cost of going above and beyond just cutting the grass.
I guess I want to hear somebody tell that to somebody whose little kid is down in that pool because he wandered in there.
Well, I secured the one side. There was like a bamboo fencing type thing, and I took 2 clips and I closed it and I put the clips on it. So, that might be enough to deter somebody, but I will tell you that every time I've been to the property, the neighbors come out and they're very diligent about shooing away people who approach the property who don't belong there. So,
can I raise a point? Is it possible for the city to take some action, pump out the pool, and then?
No.
No. So if somebody drowns tomorrow?
You have to let the system work first. Traditionally, for abatements, all we do is cut grass or take care of, visibility issues. I've tried to have the city in the past deal with a pool, and and fences, and it's not something that they choose to do.
So be it.
Any other board discussion?
Pardon?
Any other board discussion?
Sorry.
Okay, no one made a motion on this yet, right? Does somebody like to make a motion? A motion?
I would still have. If we were to find, when we find the violation, isn't there a quicker way to notify them? I mean, overnight something to them and say, you've got just 5 days.
Well, we emailed the bank right away, and when the original notice went out, the notice of violation, the bank was emailed. So it's not like we're waiting for them to respond to a letter. If I have the email address to the bank, or if I know the property preservation company, in some cases I'll call. And usually they're very, or I'll email them and I get an almost immediate response from them. But you've got, the contractors that these property preservation people hire, they're local contractors, they're just being paid to go and mow. They typically don't even report what any of the other issues are. So it takes, the email to the property preservation company to say, hey, additionally, this is what needs to be done for the property to be in compliance. And usually they'll take care of it once they're aware.
Well, I think if they had a lot shorter date and a lot bigger fine, that they'd make somebody do it quicker.
I don't think that's going to be, that's motivation. It's all about the amount of time it takes for the process with the bank and the property preservation company.
Okay.
You have to remember that there are, thousands of foreclosure cases in the state of Florida, and, they've got their hands full. It's just like, there's only 2 of us in code enforcement, and, we can only work so fast.
So, Cindy, in your opinion, though, October 28th is the most expeditious.
I honestly believe Kristen will have it done by then.
Okay.
We're just concerned, most of us.
Sure.
Well, I think what it is most of us are concerned about that open, just that they can get right into that pool.
Well, now that, I put the bamboo fencing back up, so, and I live right around the corner from the house, and I monitor it regularly, and my daughter happens to live behind that house, so there, if anything's going on there that shouldn't, she'll pick up the phone and call me, and I see it every day, several times a day. So.
That was my concern.
Yeah, it's only the safety.
And sounds like there's
I'm not trying to circumvent the system or anything like that, but on fire trucks, you see these big black hard rubber hoses that are sitting on the side of those are for drafting. When's the last time the fire department went drafting training? They can take it, drop the hose in the pool, and 5 minutes it's gone.
We would have to go through the abatement process.
We're getting off the subject. If we want to talk about that, we can actually pick that up at the summary at the end of the case. Right. Unfortunately, it looks like the fastest this can be taken care of is October 28th. I don't know if there's a way to change things in the future, but right now that's what we have before us.
I'll make a motion, Chairman.
Okay.
I move based on the testimony, evidence, facts presented in law at the time of the alleged violations, sections 8-40, duty of maintenance, IPMC 9-1, IPMC 302-.7, IPMC 303.1, IPMC 303.2, IPMC 304.2 of the Code of Ordinances of the City of Tarpon Springs were enforced. The respondent has until the 28th day of October 2013 to come into compliance with the code sections, or a fine of $50 per day shall be imposed for each day thereafter that the respondent remains in violation of the said code sections.
Second.
Justin, did you say 8-40 right at the beginning?
Yes, I did.
Oh, okay, I'm sorry.
Thank you for having that with
Any discussion on this?
Second.
I have some discussion. I want to second Wanda's concern that we just heard. And then looking at the calendar, the complaint was dated in August. The pool has realistically probably been open and untaken care of for 2 months before then. June, July, August, September, October. So we've got a system, and then this is the comment portion, that Cindy says it appears we have a second wave. I'll agree with that. I see that in my own neighborhood, is that we have a system that is not working. So we have a home in a neighborhood where the owner died, left. The home has been broken into. It's been robbed. It's been vandalized. It's unsafe. 5 months have gone by. I don't know if there's been police records. I know we have a police force that perhaps should have been protecting that home as it was stripped clean in front of everybody's eyes. That's just my comment section, is that obviously the system is broken and maybe there is something we can do to improve it.
Well, that, again, at the end of our deal here, we'll have a comment section for staff and board. And it would be something that would, I think, be worth discussing It's probably beyond the power of this board, but it would be worth discussing and maybe bringing it to the powers to be. But right now, are there any other discussion points with regard to this particular fine and case? And Bobby, could we have a roll call, please?
Yes.
Mr. DeMontis?
Yes.
Mrs. Archer?
Yes.
Mr. Casey?
No.
Mr. Kramer?
Yes.
I apologize. Should I start my roll call again? I skipped the person. Sorry. Mr. Polinsky?
Yes.
Thank you. Mr. DeMontis?
Yes.
Mrs. Archer?
Yes.
Mr. Vesey?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
No.
Mr. Sansoda?
Yes.
Thank you.
I'm glad to see that you do make a mistake every once in a while, Bobby. I've never witnessed it before. All right, item number 8, please.
This is case 13-800000709. The property address is 615 Sandy Hollow Road. The original property owner of record was Shirley O. Oliver, and the current property owner is USA Federal National Mortgage Association. We received a complaint on August 14th that this property was vacant, the lawn was overgrown, the fence was damaged, and the pool was not being maintained. I conducted a site visit on August 15th and confirmed the complaint. The front lawn had been mowed, but not the sides and rear. I could not view the pool from public access areas, and the property, the overgrowth on the side yard was too great for me to enter into the backyard. A lease pending for foreclosure was filed by Chase Bank on 12/27 of 12, and a deed in lieu of foreclosure was filed on June 18th of 2013. The property was in violation of codes 8-40, duty of maintenance of private property, 8-52, nuisance prohibitions, 36.03, fences, walls, and hedges, IPMC 9-1, International Property Maintenance Code adopted, and IPMC 303.1, swimming pools and spas. The property owner of record, as determined by the Pinellas County tax collector or by the Pinellas County property appraiser, was sent a courtesy letter on August 15th, a notice of violation on September 4th, and a notice of hearing sent first-class mail and certified return receipt on September 18th. The courtesy letter was also sent to Chase Bank. On September 4th, a new property owner appeared on the Pinellas County property appraiser's site, U.S. Federal National Mortgage Association. A site visit was conducted prior to each notification being sent. The property was posted on September 26th. I noticed an MCS posting in the window, so I emailed a copy of the notice of hearing to MCS, which is a property preservation company. I conducted a site visit yesterday, October 9th, and found no change. This property is in violation of codes 8-40, 8-52, 36.03, IPMC 9-1, and IPMC 303.1. I recommend a compliance date of October 28th and a daily fine thereafter of $50 a day.
Any questions for the city?
Yes. You said you were not able to get into the backyard, so
The grass is overgrown. I couldn't
we
get back
don't
there.
know if the pool is enclosed or secured.
The pool does have a cage.
So we're
But
assuming that it's...
considering the overgrowth, I don't know how anybody, I couldn't get back there, so
Okay, all right.
I don't think anybody else is going to be able to.
Okay. Thank you.
You're welcome.
Somebody want to make a motion?
Yes. I move based on the testimony, evidence, facts presented in law that at the time of the alleged violation, sections 8-40, 8-52, 3603, IPMC 9-1, IPMC 303-1 of the Code of Ordinances of the City of Tarpon Springs were enforced. The respondents have until October 28, 2013 to come into compliance with the code sections, or a fine of $50 per day shall be imposed for each day thereafter that respondents remain in violation of said code sections.
Second.
For discussion?
What is MCS?
Mortgage contracting service. It's a property preservation company.
Bobby, if we could have a roll call, please?
Mr. Solinsky?
Yes.
Mr. Moses?
Yes.
Mrs. Archer?
Yes.
Mr. Bessie?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
No.
Mr. Sansoda?
Yes. Nobody in the audience for affidavits of non-compliance? If I could have somebody make a motion for the affidavits of non-compliance, please?
I move the affidavits of non-compliance be accepted in case 13-800000351, case 13-800000555, case 13-800000707, and a movement.
Second.
All in favor, say aye.
Aye.
Opposed? Nobody in the audience for affidavits of compliance?
I move that affidavits of compliance be accepted in case 12-800000971, case 13-800000383, case 13-800000447, case 13-800000574, case 13-800000594, case 13-800000555, end of affidavits.
Have a second?
Second.
All those in favor, say aye.
Aye.
Opposed? Motion carries. You got stuck doing that last month because you weren't here. Approval of July
good. Okay.
11, 2013, August 8, 2013, and September 12, 2013 minutes.
I need to make a correction to those. I just want Bobby to note that we need to reflect that I'm not the city attorney. And it lists me under the invocation, I'm the city attorney each place. I need it to reflect that I'm the board attorney. And although we're referring to me as the board attorney up above as being present, it should not reflect me as being the city attorney down below, because I don't really represent the city here. I represent you as the board. So,
I like that.
I don't think online we get the minutes. I don't recall seeing the minutes for 3 meetings when I got my thing emailed.
Do we get emailed the minutes now?
Should have been part of it.
I'm sorry.
Yeah, I didn't receive them either.
you want to take a look? I brought the copies if you guys want to look at them before you approve.
I can make a motion, right?
Want to the next meeting to read them?
I was going to say, you really want to sit while I read this whole thing, and if
Yeah, why don't we
anybody else
just,
got theirs emailed?
We'll just postpone the approval of the minutes until the next board meeting.
Could I have that copy?
Huh?
Could I have that copy?
Yeah.
Oh.
You can have, I don't need it.
Justin, did you get it as part of your CSI?
I didn't get that far into it, so I may have.
Because they were scanned. Should have been part of that.
That's a lot of pages. I didn't.
No public comments, but with Wanda's concern and Carl's concern, it is with these folks. Let's just take a look at this.
Can't talk
Well,
about
yeah, that's right, we can't. But these folks have been aware of the violation on average, I would say, for at least a couple of months, maybe a month and a half. And there's nothing that this board could do, but isn't it the number one cause of a child death in the state of Florida? Isn't it drowning? Accidental drowning? I think it is. And under circumstances where safety is involved, possibly the life of a child, I wonder if the Board of Commissioners may consider abating to secure. I don't know. I mean, again, that's something that we can't do, but is it possible that an abatement might be utilized to secure? Go ahead now. My concern, though, is before it even gets to this board, because it takes a month and a half to get to this board, and if we put a compliance date of tomorrow, that's still a safety concern. No, but what I'm saying is it takes that long to get to the board, but I don't know if it would be. Well, again, we don't have the power here, but
well, let me ask.
Now we have the power to expedite the compliance date. Even if it's an unreasonable date, we have the power to expedite it. But what I am saying is some of these poles are left unattended to for a month and a half before they get to this board. So that's a month and a half of safety issues that it would be nice to figure out a stopgap measure to attend to the safety issue.
I think I might have
Chairman, can I?
Let Wanda and then Carl, then we'll be right back to you, Al.
Is it possible when you send the notice of violations out to people, and maybe in a fluorescent colored piece of paper, you say, this is a health safety issue, and the Code Enforcement Board does not tolerate a lot of time on getting these issues taken care of? I mean, tell them, you need to fix this now. And I mean, flag it, make it so loud, and say, the penalties are a lot larger when there's health and safety issues.
I agree, but I disagree, because on the ones that are in question, one bank has it, then they turn it over to another bank, then they turn it over to a maintenance company. You're going to put one of these special letters out? I mean, go ahead.
You had indicated you were going to recognize me after Wanda.
Yeah, but I wanted to see what you were going to say. What was your response to Wanda? Cindy, you were getting ready to respond to Wanda.
Y'all have your discussion first. I'll say my piece.
Okay, Carl?
I would just like to make the point that whether we as a board have the power or not, the city itself has a power and an obligation and a moral and ethical responsibility to protect its citizens. Okay? And when I was asked to be a part of this board, that's what I was given to believe was part of my duty and responsibility. So what I would strongly suggest, whether it takes the attorney who's representing the board, you as chairman, or I'll do it myself, somehow we have to get to the proper authority. If we don't have the power, someone, and put the politics aside and the fact that one faction doesn't like the other, we are now aware of a situation that potentially could be very, very dangerous. And I think somebody has to say, listen, whether it takes the fire department, whether it takes a change in the code, I'm not putting it on Cindy, I'm not putting it on you, Mark, and then I'm not putting it on the attorney. But I'm saying somebody has to take some action based on what we've seen here. Because I don't want to have something happen in the next week or the next day or the next month and say, I was aware of that situation. And I absolutely am assured that even though we often disagree with each other, that there's not one person that's sitting here that wouldn't feel the same way. None of us want to see a tragedy. So let's at least try to make somebody aware of, so that we can get some action. If it's not our prerogative to determine that action, it has to be somebody's. We can't let the city of Tarpon Springs fail. And that's my point.
No, I feel it has to be something with the city commissioners, the city fathers. Have to make a ordinance or whatever that somebody immediately, when a house goes in foreclosure, they are going to step up and
Protect
take
the pool.
responsibility, if nothing else, for the pool. I don't care if the yard's overgrown, then that can come to us. But as far as the pool, as safety and liability concerned, you can't tell me something can't be done by the city of Tarpon Springs.
Well, we wouldn't walk away if there was an open flame. You know, we wouldn't say, well, that's the fire department. You know, we would at least get in touch with the fire department and say, we have to do something about it. And I think we have a moral responsibility based on what we are now knowledgeable of to carry it through somehow. I hate to think that we're that hopeless that we just say, well, it's not our prerogative, it's not part of our it's not part of our actions. I'll admit, it's not for us to do it, but someone within the city, I would think, would want to protect the life and limb. Especially, I mean, we've heard from our inspector that, you know, unfortunately, she lives right around the corner. She has a daughter who lives right near there. I'd hate to think that some tragedy could take place. Well, then let's go out and pump the damn thing out. Exactly. I agree with you 100%. We got fire trucks. We got somebody. We got an engineering department. Somebody could take a look. I have to tell you, I lived in Naperville, Illinois before I came here. If that had happened there, the city would come out, pump it out, charge you for to have people pump it out, cite you, fine you, okay? But the first thing they'd want to do is take care of the problem. And that's I'm going to stop now. I'm sorry.
You can't pump pools out here. They pop out of the ground because our water table is too high.
And
bar the door.
Yeah.
In past cases where there has been a pool involved, usually by the compliance deadline set by this board, the pools are taken care of, either by covering or by getting the pool equipment operational. And that depends on how far along the foreclosure process is. But I've not run into an instance with a previous case where the pool has not, with the exception of one. And I tried to get the city to secure the fence in order to prevent people from getting back into the open pool. There was no enclosure. And I was told that the city will not use abatement money for repairing fences or for pools. The abatement process covers allowing the city to go onto private property to mitigate violations. The process is that a letter and a posting notice has to be applied to the property and sent to the property owner from the city manager, attested by the city clerk. They have 10 days to correct the violations, or at the end of 10 days, the city can send a contractor on the property to correct the violations. Now, typically, for the last 7 years that I've been doing this job, the only thing that we have abated were overgrown lawns.
That's so smart. Yeah, keep those lawns short.
But as far as the pool goes, I think you're looking probably at additional liability for shocking it, covering it.
No, just the open gate, the open door.
But again, it's really not. Once the companies are notified, and once, like I said, these cases come into compliance by the compliance deadline. And I know it's I know you want to have it abated, have the city go in, but number one, it costs money. And number two, you're still looking at additional time to post that property to be able to do it. Plus, I can't just order the abatement. I've got to go to my supervisor, who goes to his supervisor, goes to her supervisor, who has to go to the city manager to get all this approved.
I don't think anybody's trying to make it your job, Cindy. That's not the issue. Nobody's trying to say you didn't do your job, or nobody's trying to put more work on you.
No, I would like to...
I understand where you guys are coming from, but, I think that would be up to your chairman going and sitting down with the city manager to see if anything can be done.
Maybe it should be done that way.
That's the process. If you would like to see something changed or, handled differently, then you need to give your chairperson the authority to represent all of you So you can go and sit down with the city manager and see what can be done.
I'm more than happy
Now,
to do that, but that would...
I will tell you...
Go ahead. But would that...
I will tell you, a couple of years ago, I submitted a proposal to the VOC to have them entertain the idea of registering foreclosed properties. It's something that other municipalities have been doing, and it's been successful, but at that time they didn't feel a need for it. I still, I understand that, and I honestly don't see a need for it, but that's one way to get the banks to act a little faster if they know that there is a registration ordinance for foreclosed properties.
So sitting down with the city manager, though, would that have as much impact as addressing the Board of Commissioners?
Don't blindside the VOC. You need to go and sit down and talk with the city manager.
No, I would have sent them a letter initially.
So make an appointment and go talk to Mark.
Okay.
Bring the issue up. Good. I would just morally feel better knowing that at least we've taken some action. And I appreciate you. Okay.
Attorney Trask, what do other municipalities that you represent do with regards to unattended pools?
We're doing the exact same thing that the city of Tarpon Springs is doing. Moving it through either special magistrate code enforcement or code enforcement board, or abating to the extent that they're boarding up areas, a way to get into the pool. But I'm not aware of any city of the 9 that we represent that actually go out and pump a pool or cover a pool.
Well, if they secure the entrance, I just think that we have an obligation to know that it's protected. However, whatever system the engineering department of the city feels is best, I just think that the city should take some type of action, whoever's budget it comes out of, to protect the citizens. Because all of us, not one of us, whether it's never happened before or not, if something happened tonight or tomorrow morning, and we all had to face that in our newspaper, we would all be terribly, terribly upset over it. I think that's great.
Well,
it doesn't have to be a tragedy. Tragedy is the fact that a home is allowing to be broken into and just being disassembled in front of its neighbors without protection. As much as the pool issue is very severe, we're better than that. We're better than that. That house is being disassembled in front of our eyes. That just shouldn't go on. What else is the city for if not to protect its citizens against that? We're not here just to provide jobs for city employees. We're here to protect the citizens against exactly that.
I'll schedule a sit-down with Mark. I would do it as soon as possible. If he has time today, but I would like to at least try to figure out some type of I would like to see, as Carl was saying, that it be boarded to if it's a broken door on a fence, fix the door or seal the door. I'd like to figure out what idea that we have as a board to address the situation in as expeditious a manner and inexpensive a manner as possible. And it seems to me if you have a missing door, then something to replace that missing door.
Something that happened before this meeting, these cases have been going on for 2 months. And so if they come to compliance in the next 2 weeks like they're told they're supposed to, that's great, but what about the last 2 months?
Even so,
we need to be able to go in and board those doors up the day that the doors are noticed open.
Yeah, I mean, we have 2 weeks in which something could happen. And again, there's a reason why this is the highest child fatality rate in the state. So this situation needs to be addressed. And I think we're talking pretty fervently, but I think our demeanor would change if, something was in the newspapers in the next couple of days. So I will,
Mr. Grant, do we have to make a motion to give Mr. President the authority to the board?
President, obviously it would be a lot, I'm sure he would feel a lot more comfortable if there was a motion made to allow the chairman to to go this direction.
At this time, then, I'd like to make a motion that we give the president of our board the authority to speak for the Code Enforcement Board of Tarpon Springs, Florida.
I will second that.
all in favor, say aye.
Aye.
Opposed?
If you need help, I'd be more than happy to stand by your side.
All right.
Go get 'em, Tiger.
Came in one before the other.
They could have come into compliance, they were non-compliance when they were supposed to be, and 2 days later they came into compliance, and it all happened before the last meeting, or since the last meeting. Yeah. Yeah, it's not really that unusual. But that's the reason why. So we have a starting point and a cutoff date. Okay.
Any other board or staff comments?
I'd just like to make a quick comment. I'd like to thank you, Mr. Chairman, for your willingness to go directly to the city manager and make an effort on our part. I understand that it's beyond our scope, but I feel better knowing that you will speak to the powers that be. And, sir, I don't know your name, but the gentleman at the end, Al, one of our alternates, I'd like to thank you, too, for your volunteering to speak to the mayor. And I think that with both of you gentlemen being involved, I'll sleep better tonight knowing that we're going to, one way or the other, get this thing rectified, and then we don't have to be concerned that some poor child will suffer a terrible incident. So thank you very much, both gentlemen.
I do want to clarify that we don't have the power to make the decision, but we, as a board, have a lot of sway in our, and so like I say, I will sit down and say that it's a unanimous with this board that we want to address this situation, and certainly before the next emergency and tragedy happens, and there will be another tragedy. Unfortunately, because that's just the way the kids are. And my two grandkids are really ornery and really into jumping in any little dish of water they can. And well, thank you very much. Any other board comments? It's 3:24, and we adjourn.